My lord, this is a unique case in two respects. One, that there is an omnibus demand. Same-sex, transgenders of 72 kinds, intersex, genders, third-degree genders, all. So, all, my lord, together, everybody wanting an equation with heterosexual marriage. And for that purpose, requesting your lordships to amend drastically the Special Marriage Act. My lords. And this second is, my lords, that this is a demand, my lords, for equation, not simply set a right to marriage, but to a right to marriage at par in the same sense. Now, three questions will arise, my lords. Is there a fundamental right to marry? Is there a fundamental right to recognition of marriage? And is there a fundamental right to equality in matter of marriage with heterosexual?
Which is the second one?
Is there a fundamental right to recognition of marriage? And is there, third is there a fundamental right to equation or equality in matter of marriage with the heterosexuals? And the fourth will be, lords, that if there are all these three rights, then can that be made permissible by this variety of amendments? Just to recapitulate, lords, one demand was, and focusing on the Special Marriage Act first, lords, Mr. Rohtagi said, my lord, read husband and wife as spouse, man and woman as person, everywhere, and operate both the schedules at the end of the act, prescribing prohibited degrees for the purposes of accommodating same-sex marriage. Then there was one, my lord, suggestion that 99% of the transgenders could be accommodated as women, or as per claim, whatever they put up. Yet another demand was, my lord, that this will not be sufficient to accommodate the third genders. So add some age which your lordship considers appropriate, either 18 or 21, and make that addition. Now, the learned Solicitor General has taken your lordship through the Special Marriage Act, my lord, and various cases to suggest why all this cannot be done. This is too drastic. And various reasons have been given without reiterating, but adopting them. I only want your lordships to look at Section 4. Lord, spouse is a flexible.
Section 4, sorry, Mr.
Section 4. Section 4.
What is the submission?
The submission is that spouse, grammatically, my lord, may be a flexible word, but if one considers the context of the act, my lord, here the spouse means either the husband or wife. Because the context of this act is heterosexual, everybody agrees to that. Not even the petitioners don't contest that, but except that they want substitutions. And if there had been any doubt, my lord, then B, 2 and C make it further clear. Now kindly look at 12, section 12. The marriage may be solemnized at the office of the marriage officer or at such place with reasonable distance and so and so. The marriage may be solemnized in any form in which the parties may choose to adopt, provided that it shall not be complete and binding on the parties unless each party says to the other in the presence of marriage officer and the 3 witnesses and in any language understood by the parties, I, A, take the B to be my lawful wife or husband. So a husband-wife relationship. Now, the contention is that substituted by spouse. Is it a simple substitution, Mulad? You set up your claim based on choice, autonomy, dignity, fraternity, and all those. Now, is not, Mulad, there a dignity for the heterosexuals, Mulad? Because you are asked to substitute this by spouse.
How is the dignity of heterosexuals affected by that?
No, because the relationship of husband and wife is a meaningful relationship since antiquity. Husband, wife, pati,
But
patni.
do you mean to say that by recognizing, we're just testing the argument here.
Yes.
That the dignity of the relationship between a heterosexual husband and wife would be affected by granting recognition to a same-sex couple?
No, not that.
Mr. Dwivedi, what you're
Not
suggesting
that,
is by using the word spouse, the argument you're making is it diminishes the dignity of the husband or the wife.
That's.
Who wants
I'm
to
not
be
saying.
called as a
I'm not
husband
saying
or
because of them you give anything you wish they are
Husband and a
entitled.
wife are still a spouse.
still spouses.
No, but
You want to be called as.
when we say that I take you as a husband, I take you as a wife, you want us to say that I take you as a spouse?
That's not your strongest point.
No, it's
semantics.
It is.
The first point that you made, about amendments, well taken. I mean, no doubt about it. This part, I think, is.
No, it is, my lords.
See, this
All right, we
is
make a
perhaps
note.
your
My
root.
lord, the question is now how your lordships or I think, my lords. Please look at it this, my lords. How I take it. How the society, my lord, people who marry every day.
I think, Mr. Dwivedi, yes.
Yes.
Mr. Dwivedi, what you're driving at is essentially this, that you're not looking at this form, but you're looking at the traditional form where
Yes.
in almost all traditions, in all cultures, do you so-and-so take so-and-so as husband, do you take so-and-so as a wife? That part is what
Yes.
you are emphasizing.
That's right.
But then the argument, of course, it boils down to how are you diminishing the dignity of that
No,
choice?
because, my lord, then every time we go to the marriage officer and we say, I take you as a spouse.
It doesn't preclude you from treating each
No,
other as husband and
but why change it? Why alter it?
Mr. Dwivedi, when you say that I take you as a spouse, that is also consistent with I take you as a spouse who's my wife.
Because
I take you as a spouse who's my husband.
spouse is flexible. Now your lordship, when your lordship substitutes, then it is not in the sense in which it is used in section 4.
So what is that sense? That's the question.
In section 4, the sense as it is husband and wife, because this is a heterosexual marriage regulation. But now when your lordship will make all these substitutions, then this act will turn into an act which covers other relations also.
That is a different point. That you made your point, and there can't be any doubt about it. That the acceptance of the argument
What
does require substantial rewriting of the provisions of the Act.
that has been addressed,
which
Lord.
is legislated. That's
Yes.
been addressed. No
What
question.
I am submitting is that while sort of claiming dignity, you should not inflict indignity. Whether look at it traditionally, culturally, historically, socially. These are very valuable things, may have no meaning, my lord, for the people, my lords, who don't attach value to it.
Brings it out better.
But
Therefore, in a sense, what you are saying is that, look, marriage, which is recognized by the Special Marriage Act, conventionally understood as a union between a heterosexual couple. And by recognizing anything apart from that, you are affecting traditional values.
so don't dilute the status. Don't, my lords,
got the point.
small tinkering
What is the next point? We got
create
yes,
a boil in the society.
all right. What is the next point now?
Lord, if your lordship recollect, Lord, in Sabrimala, my lord, your lordship's constitutional bench took a view. And there was a virtual counter-revolution on the ground. And this court, my lord, backtracked and referred the matter to 9 judges, and there was a stay, and we are where we were. Lord, there are many matters of social reforms, my lord, which may appear to be constitutionally this side, that side, but when we try to preparedness of the society to accept that change is also extremely important. Let's not rush. Indian society is always not more in tune with evolution, not cultural revolution. And that too, my lord, a request of cultural revolution through adjudication. China tried, failed. Russia tried, failed. They all had to backtrack, my lord. 70 years of Russian revolution, my lord, then we are back, my lords. Communism gone.
Except with one difference, Mr. Devadi. We have a constitution with an enforceable chapter on fundamental rights.
Yes. But fundamental rights don't operate in vacuum, my lord. They are all meant for ultimately to operate in the context of a society, given society. And that's why I'm averse, my lord, when some of us, my lord, try to cross the seas, my lord, and we try bring Obergefell here, bring, my lord, Fori here. So
no, but Mr. Dwivedi, let's be very clear. The existence of same-sex couples is not something which has been imported from some ocean-going.
No,
it's as much a part of our society as
it's part of society, and there is another aspect which is not looked at, and that is that even though it was there in the society, my lord, at no point of time there was any demand or recognition of marriage for them. That's also equally aspect. They were there. They were given respect. They had dignity. Marriage, my lord, I'll come to that, but marriage, my lord, by itself is not a matter of dignity, my lords. If that were so, then people who are not married, my lord, have no dignity, my lords. It can't be that. People, my lord, who become widowers, my lord, and then they are not married anymore, so they lose dignity upon becoming a widow. It can't be that.
That's not the argument. The argument is not that, people who are single lack dignity, or that marriage is the only source of dignity. The point is about choice.
That's right. So therefore, dignity has no relevance. Maybe equality, maybe choice. You can choose your partner, live with the partner. But if you want to marry, that's a particular social. You are then invoking a particular social institution which is existing in the society. Otherwise, my lord, who's stopping them from forming any kind of association? You marry, there's no law. I would be very happy, my lords, if all these laws are taken away, my lords. But these laws are there to protect the interest of women and children because of the command of Article 15(3), which says that state can make a special provision for emancipation of women. Therefore, these regulations have come in. But dignity, my lord, has nothing to do with marriage. My marriage is not registered, as your lordship noticed, my lords. So I have no dignity, my lord, that means. I'm not looking for any recognition from any law. I don't want the parliament, etc., my lord. We never depend on the state. Here, there is a particular reason for demand of recognition by state or by court. And that is that Mr. Rohtagi said that we want to use your lordship's prestige to bring about social acceptance. It's all about social acceptance. Otherwise, make any number of judgments, any number of laws made by Parliament, my lord, will not create social acceptance. It is only social evolution in which, my lord, the representatives of people participate. That alone, my lord, can bring about social acceptance. I am not inimical to their relationship. But what is the way about? It's the social evolution involving representatives and not a cultural revolution through court, my lord. In all matters of social revolution or social reforms, your lordships have granted legislators, the parliament, a choice how to proceed. You may deal with some one section at a time. All laws need not be all embracing. Sometimes, my lord, the laws are made and tested and experimented in one particular area. It need not be throughout the territory of India. It can be piecemeal. It can be phased. And the phases can have spacing, my lord. Look at the women rights case, my lord. Women got right to maintenance in 1937. It was blown up into a bigger right, my lord, in 56. They become co-parsoner, my lord, in 2005. And even today, my lord, they don't have rights in under the Agricultural Reforms Acts.
Section 4.2.
Yes. So therefore, my lords, how many years have passed? There was something said, my lord, that we are getting old and so on, my lord. So, my lord, if it's a cause for which you are battling, all causes, my lord, take time to succeed. And all causes have their martyrs. It's not necessary. Why? It's not an individual thing that I got married, I did not get married. I left the world without getting married. The issue is, this is a cause which requires social accommodation, and therefore Parliament, which has the pulse of the people in hand, are in the best position to decide when to take the next step, what should be the next step, and how should it be brought about. These are sensitive areas where the courts, my lord, as far as possible should keep away and not force things. That's what I'm beseeching your lordship, my lord. Don't force it, my lord. Because, my lord, the whole social fabric can be rent apart. We do not know what consequences will happen or not, Lord. I'm not trying to predict something, but slowness is the way forward in such matters, not speed. As we go in the mountains, Lord, there are always warnings that be slow, else there is danger. Now, Lord, there's another aspect. Kindly advert to section 43 and 44. I'm placing only those sections, Lord, which have not been placed, to the best of my recollection. Penalty on married person marrying again under this act. save as otherwise provided in chapter 3, every person who, being at the time married, procures a marriage of himself or herself to be solemnized under this act shall be deemed to have committed an offense under section 494 or section 495 IPC, as the case may be, and the marriage so solemnized shall be void. Punishment of bigamy. Every person whose marriage is solemnized under this act and who during the lifetime of his or her wife or husband contracts any other marriage shall be subject to the penalties provided in section 494 and 495 IPC for the offense of marrying again during lifetime of a husband or wife, and the marriage so contracted shall be void. So the provisions of bigamy have been bodily incorporated by reference. Now there are two things, Lords. If we substitute wife or husband by spouse, what happens to the application of 494-95? Your Lordship will have to then also say that though this substitution has been done as spouse, still that provision will apply. Now, here also it will be substituted as spouse. So some relationship which is as yet
IPC one.
the entire chapter 20 seems to be crafted around a relationship between a man and woman. So do we substitute person here also? Every person who by deceit causes any other person who is not lawfully married to him to believe that she is lawfully married to him and to cohabit.
495 same person.
Or 494 is bigamy. Having a husband or wife living, you can easily say we have no husband, we are not living as husband or wife. Or they may say that there was some strain of argument that one of us, we can choose a role. So therefore, Lord, there are two things, Lord. How do we substitute this? It's a criminal offense. Are we going to, by adjudication, create an offense with regard to, by bringing them in and substituting, Lord, here also?
Fair enough that you've made your point, yes.
What happens to the mandate of Article 20? Offense can be created only by law. So the substitution here is virtually impossible. There's no way. Because even if we assume that you can substitute, we are then creating offense. And there are only 20 petitions here. We are told, Lord, that overwhelming majority wants to get married. I do not know whether they have pondered that all of them want to get married under this act and subject themselves to, Lord, this offense of bigamy. And even if they want to, Lord, it can't be done. But we don't know. Tomorrow, one of them can come and say that, why have you included here? How could you create an offense? So therefore,
Interesting.
Just apropos what you were saying, we were just discussing amongst ourselves.
Yes,
and
yes.
It's not my own, but all of us put together, we've discussed this.
Yes.
Suppose there's a same-sex couple, and in that relationship, one of the persons in the same-sex relationship marries a person of the opposite sex. Then strictly speaking, this provision for bigamy will not be affected at
Apply
all.
to them. As it is not applicable.
So if there are two men in a relationship and one of them marries a woman, there'll be no offense of bigamy. Of conversely, or as Justice Bhatt was saying, suppose there is flip the same situation in relation to a trans person, right? Sorry?
A person who who discovers that he is a transgender person, who's already married, and then wants to enter into a relationship.
Same-sex relationship.
Same-sex.
Yes.
There's no bar then.
And then there are people, my lord, who have fluidity, my lords. What do we do with that, my lords? How do we create an offense, bring them into this?
So in other words, your submission is that in order to take care of a myriad situations, it's really for the lawmaking body to enter upon the...
All these factors, my lord, will have
We got
enter
the
the melting pot, my lords.
Yes, Mr. Reddy, you have given us...
Look at the tools available to the parliament, my lords. They have select committee, they can form any other committee. Of course, your lordships can also form a committee, my lords, to go into all that, my lords. But it will be sort of preventing the parliament from doing its job and taking a step before they take.
Any other provision of SMA apart from 43 and 44?
Then they have the law commission, my lords.
And the attorney generals are sometimes also members of the law commission.
Yes.
First law commission.
The first law commission. Also, our attorney general was, of course, not in his capacity as AG. He was not then the AG, but...
So all these tools are available to...
AG was a member of the law commission.
Yes. Good chocolate.
This adjudication, I would say again, with utmost deference, Lord, is happening, Lord, in the absence of states, Lord.
Absence of?
States. Section entry 5 is in concurrent list. Even if Parliament does not legislate, the states in their own territory can.
You are appearing for one.
I have appeared, my lord, but my application is still lying, my lords. I have not allowed it, my lord. As
then what are we doing? But we are hearing you, Mr. Dwivedi.
No, hearing as an intervener, my lord. And pleading with an opportunity is...
So how many Dwivedis do we have to hear to get all the states represented? One is good enough, Mr. Dwivedi.
Not even one is necessary, my lord.
There's another one.
There's another one here next to you. How Dwivedi needs to.
No, Dwivedi doesn't mean two, Lord. It means those who have read, those who have
Vedas too.
But unfortunately, I have not read even one. And there's another saying, Lord, that Dwivedis are those people.
Three times the Vedas.
Chaube is also, Lord. Chaturvedi is also. It is said that there are certain persons, Lord, who became over-ambitious and they wanted to write 2 more Vedas. So they were punished and they became Dwivedis, Lord. So over-ambition is bad. Well, the only other provision which I wish to draw attention to is one of them had been drawn place, that is section 4B2.
That you've already mentioned, 4B2.
It has been mentioned, but read it along with 24.
Any of the conditions specified in B.
24, 1 and 2. And 2, which talks of impotency at the time of marriage, at the time of institution of suit. Just note that, I'm not building any big.
What is the next point, Mr. Dwivedi?
Seek a nullity of the marriage.
Oh, that's all right. Nullity can be sought. Yes. Now, I'm not reading, my lord. I hope your lordship has my written submission, my lords.
Yeah, Kapoor is what he point kept.
Final written submission.
Second,
We're looking at the final, A's final.
second.
There's one paragraph in the original one. I don't know whether it's in the final one.
Because submissions of learned attorney general were so elaborate that I had to keep on deleting. my lord. And the process, once I deleted some
You may
pages,
want to read page 6, para 8. I thought that's a very interesting.
Final written submissions, right?
Yes, fine.
Finally.
Para 8.
Printed or final?
yes,
I mean-
para 8.
Para 8 is that.
That's it. Although in para 7 also there is one judgment, my lord, but the number of your lordship will see that. In para 8, I have extracted para 39. That was in the context, it's a constitution bench judgment. Section 8(4), my lord, before it was declared ultra virus. Opens with the word notwithstanding anything in subsection 1, subsection 2, or subsection 3, and it applies only to.
This was the chief minister 6 months ago.
Yes.
Yes.
Sitting members of legislatures, there is no challenge to it on the basis that it violates Article 14. If there were, it might be tenable to contend that legislators stand in a class apart. In any case, if it were found to be violative of 14, it would be struck down in entirety. There would be and is no question of so reading it that its provisions apply to all legislators and non-legislators, and that therefore in all cases the disqualification must await affirmation of the conviction and sentence by final court. That would be reading up the provision, not reading down, and that is not known to law. So,
Yep.
so just by way of side note, if one of the monitors could be in front, my lord, we could see justice call, my lord.
It's not.
Oh, you're not able to see justice call?
Oh, this is very side, my lord.
All right, we just, we'll get it, yes.
If there is some, then it will appear as.
Certainly we'll get it done. I'm sorry, I thought you could see.
I'll put it in front of me.
Can't we switch the screen?
Is there, no?
You can bring the screen.
तो हम देख नहीं पाएंगे फिर lawyers को देखनी है हाँ you can bring justice call on the
That's
हाँ,
right.
other side on the other
If there is a.
Justice call is the focus of attention right now.
I am Mr. Dwivedi doesn't like a side look of mine.
Some profiles are straight.
Overall personality, my lord, is great.
Actually, ideally it should be there somewhere. Should be there somewhere.
Yes.
Fine. Is it
Right.
better?
That's right. So that
I brought it here.
maybe in this somewhere here in the corner.
keep seeing at the bar and
Is it better on your screen now?
Yeah, I can now.
एक
my lord.
हमारे तो होना चाहिए मैं कह रहा हूँ उनके भी एक होना चाहिए.
Close up view is it.
So, my lord, they briefly touch upon three aspects, my lord, now. That is, Mr. Kripal said, forget the original legislative intent. This court has discarded originalism. And then Mr. Vishwanathan, my lord, referred to Nakara line of cases, my lord, to say, to buttress the submission that alterations can be done. Mr. Singhvi referred to Ghedan, my lord, Ghedan has been dealt with, my lords, already. Now, with regard to originalism, my lords, my lord, the Chief Justice, my lord, had in para 251 and 262 of Puttaswamy, my lords, your lordships made some observations, my lords. I think, my lord, this leads a little more clarity, my lords. In what circumstances, my lord, originalism can be discarded, my lord? Because to say, my lord, that originalism, my lord, is courts are not bound at all, my lord, then in every case we can just forget, my lord, what the legislative intent is or what the framers had said. Whereas in Puttaswamy, my lord, the Chief Justice, my lord, even while saying that there are certain, your lordships have very carefully, my lords, headlined this portion by saying limits of originalist interpretation. This is not the volume 1, compilation 4 of the petitioners, PDF 567.
Have you quoted those two para 295, 296?
No, that's not quoted.
No, it is, isn't it? Para 15? You're not referring to 295, 296?
That's on another aspect.
Not on this. What
Not
paras
on-
are you referring to, please?
This is para 251 to 262. And it is PDF 567. Constituent Assembly and Privacy in Limits of Originalist Interpretation. May I place it? The founding fathers of the Constitution, it has been urged, rejected the notion of privacy being a fundamental right. Hence, it has been submitted that it would be outside the realm of constitutional adjudication for the court to declare a fundamental right to privacy. Argument merits close consideration. Then your lordships have quoted, my lord, from 252 to 258. Kindly come to the last 4 lines of 258 at PDF 570. From this, it cannot be concluded that the Constituent Assembly had expressly resolved to reject the notion of right to privacy as an integral element of the liberty and freedoms guaranteed by the fundamental rights. So it did not really involve, my lord, any rejection of the original intent. Then in 259, the Constitution has evolved over time as judicial interpretation led to recognition of specific interests and entitlements. These have been subsumed within the freedoms and liberties guaranteed by the Constitution. Article 21 has been interpreted by this court to mean that life does not mean merely a physical existence. It includes all those faculties by which life is enjoyed. Then your lordships trace all that. Lord Cooper is there in 260. I'm not reading that much.
Interpretation of constitution cannot be frozen. So
No, that's right. It can't be frozen. Then in 261, 262, technology, etc., has been mentioned. Now, what is being said is that the fundamental rights, my lord, have got penumbras. They have, and as time advances, new technologies come, then new rights can be read into it. Now, this originalist, the limitations are being considered in the context of expansion of fundamental rights alone. It has nothing to do with interpretation of legislative enactments, where n number of judgments, have stated that the court's task is to discover the legislative intent and the object and to take that interpretation which advances it. So this is discarding of originalism, my lord. That is the original view. That is the original view of the framers of the Constitution, is resorted to in rare circumstances and because of very strong elements, my lord, which may be present. For example, my lord, in Skora's case, when the lordships brought in the idea of independence of judiciary as a basic feature and collegium, my lord, was born, then it is because of the basic structure doctrine, my lord, which was applied, independence of judiciary was applied, and therefore, my lord, your lordships discarded what Dr. Ambedkar had said. In the assembly, my lord, it was somebody had said that but this will lead to concurrence. Even consultation can be interpreted as concurrence. But that was rejected by Dr. Ambedkar. That cannot be. However, my lord, in Scora, your lordships discarded it, but that is because of a subsequent evolution of a very important aspect of constitutional law, that is the emergence of basic structure, my lord, in Keshwanand Bharati. So that was the reason where your lordship did. But look at what your lordships did in this case.
That is virtually within the.
The legislative intent
Known as
at the mere asking would be, my lord, committing that act which Justice Cardozo, my lord, has warned the judges are not a knight errant roving at pleasure, my lord. So we can't just pour anything we wish. Then how do we do it? Then we have to, my lord, perforce go back to the legislation and discover, my lord, what is that legislature wants to do, and then some iron out some crease, do some chiseling, do some minor surgery, not a major, my lord, surgery. Now, very importantly, what my lord the Chief Justice has himself, my lord, dealt with regarding due process. Lords will recollect, my lord, that this point was raised by me only because, my lord, Justice Nariman had in some judgment said that because of Menaka Gandhi, my lord, and
Brought in substantive due
it
process.
has full circle now. So we are back to due process. So that was the point raised in which your lordships have. Paragraph 273. I have quoted that, but if your lordship...
I think I cited the Oxford Handbook of Constitutional Law, isn't it? Just see one of the footnotes there, I think. Just
Sorry.
around there, I cited the Oxford Handbook of Constitutional Law,
Yes,
I think.
yes. Now kindly see 273, my lords, a PDF 578.
Just read it out, yeah.
There's only one error which your lordships committed, my lords.
I can correct it. I have an opportunity now.
No, I don't think it can be corrected. During the course of the hearing, Mr. Devedi, learned counsel appearing for state of Gujarat, my lord, I never appeared, my lord, but I can probably now send the bill, my lord, too.
Who were you appearing for, Mr. Dvedi?
I appeared for Odisha. And...
See, even your junior is not agreeing with you.
The lordship then traces in the history, my lords, of this due process in para 274. And finally, your lordships have also noted, my lord, how just Mr. B.N. Rao went to and met
Justice Frankfurter.
Justice Frankfurter, and how the changes were sought to be made, and Dr. Ambedkar, my lord, observation in para 278.
Alladi 277.
And in 278, at the end, your lordship says the amendments proposed by some members to reintroduce due process were rejected on 13/12/1948. So several attempts to bring it back, they were repelled. Having noted that, then your lordships even noted Justice Krishna Iyer's observation in paragraph 282, where he said, "True, our constitution has no due process clause or the 8th Amendment, but in this branch of law, after Cooper and Menaka Gandhi, consequence is same." This was also noted. And then in 292, significantly, your lordships depart from what the US position is. The lordship said, in dealing with a substantive challenge to a law on the ground that it violates a fundamental right, there are settled principles of constitutional interpretation which hold the field. The first is the presumption of constitutionality, which is based on foundational principle that legislature which is entrusted with the duty of lawmaking best understands the needs of society and would not readily be assumed to have transgressed a constitutional limitation. The burden lies on the individual who asserts a constitutional transgression to establish it. Secondly, courts tread warily in matters of social and economic policy, where they singularly lack expertise to make evaluations. Policy making is entrusted to the state. Then the lordship referred to doctrine of separation of powers, my lord, which also sometimes misunderstood as if it is only one way, my lord, creating an independence of judiciary. Whereas, my lord, even going by the founder of this philosophy, Montesquieu, my lord, it is the freedom of independence of all three organs. They are co-equal. He says, my lord, a very significant expression that the interplay between these organizations is one of dissonant harmony. So there is some rubbing against
Friction.
some corrections, some checks, some balances, but ultimately they exist in harmony. The lordships have quoted that. Then Justice Patanjali Shastri's was
The last
observation.
part of it is what you are actually.
Yes, 295, 296. Your lordship.
No, in 293.
I'm sorry.
The last part of the extract, apart from that classical test
Yes.
of what is reasonable,
Reasonable.
in evaluating such
Elusive.
In evaluating such elusive factors and forming their own conception of what is reasonable, in all the circumstances of a given case, it is inevitable that the social philosophy and the scale of values of the judges participating in the decision should play an important part. And the limit of their interference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint and the sobering reflection that the Constitution is meant not only for people of their way of thinking, but for all, and that the majority of the elected representatives of the people have, in authorizing the imposition of restrictions, considered them to be reasonable. The court, in the exercise of power of judicial review, is unquestionably vested with the constitutional power to adjudicate upon the validity of law. When the validity of law is questioned on the ground that it violates a guarantee in Article 21, the scope of the challenge is not confined only to whether the procedure for deprivation of life or personal liberty is fair, just, and reasonable. Substantive challenges to the validity of laws encroaching upon right to life or personal liberty has been considered and dealt with in varying contexts such as death penalty and mandatory death sentence and other cases. Person cannot be deprived of life or personal liberty except in accordance with procedure established by law. Article 14 as a guarantee against arbitrariness infuses the entirety of 21. Then leaving that, kindly come to 295 and 296, not from the sentence beginning hence. Hence, while judicial review in constitutional challenges to the validity of legislation is exercised with a conscious regard for the presumption of constitutionality and for separation of powers between legislative, executive, and judicial institutions, the constitutional power which is vested in the court must be retained as a vibrant means of protecting the lives and freedoms of individuals. The danger of construing this as an exercise of substantive due process is that it results in the incorporation of a concept from the American Constitution, which was consciously not accepted when the Constitution was framed. Moreover, even in a country of its origin, substantive due process has led to vagaries of judicial interpretation, particularly having regard to constitutional history surrounding the deletion of that phrase in our Constitution. It would be inappropriate to equate the jurisdiction of a constitutional court in India to entertain a substantive challenge to the validity of law with the exercise of substantive due process under the US Constitution. So, Lordship respected the originalism.
No, not really. Not really. What we really had, this was, you're right. You had shown us Justice Nariman's judgment, virtually saying that substantive due process is now a part of our process of judicial review. What we said was that substantive due process in America itself has now become almost a disbanded phrase for this reason, that substantive due process was used to virtually supplant the policy of the legislature. You know, when substantive due process was adopted, that was particularly in the context of the cases in the years of the Great Depression between 1929 and 1933, when Congress was bringing in social welfare legislation such as minimum wage, maximum hours of work, conditions of labor. A lot of those legislations were struck down on the ground that they interfered with the freedom to contract.
Laissez-faire.
Laissez-faire. And therefore, they really, that was a core doctrine of substantive due process. We said this has never been adopted by our constitution.
So that's what I'm precisely saying, that the lordships refer to what happened in the Constituent Assembly. And then your lordships took this view that though there is an advancement, the substantive part can be tested, but with all other hedgings in law. But your lordship said no to due process. This is important also for this reason that Obergefell strongly relies upon due process. It's not been discarded. The judgment of Justice Kennedy, the majority judgment, relies upon due process. I'm not saying that a similar view cannot be taken, my lord, if your lordships through the route of Maneka Gandhi or other. That's a different exercise altogether. The wisdom of the legislation will not be tested. That even our court has said several times. We will not substitute the views. So, in that context, I'm submitting, my lord, that originalism,
It comes down to classification.
and I'm requesting.
Exactly.
Fall back on classification. You're
Yes.
saying that, yes, there is possibility in that side, whatever they are arguing, but this is a classification.
Yes.
That's a part of the classificatory process. But the counterpoint there then is, in that classificatory process, you've excluded. One can understand if there was a
I
positive.
appreciate it. I'll respectfully, my lord, answer when I come to Article 14, my lord. I'll present my views. At the moment, I'm only saying, my lord, that this prayer to discard originalism, particularly in the context of, we are not construing, my lord, as some advancing some fundamental right here. Question is statute, Special Marriage Act as it has been made, as it exists. Can we discard its intent? You strike down. We have no problem, my lords. Heterosexuals will have no problem, it is struck down. Our marriages, my lord, don't rest on any of these laws. They bank on customs and personal laws, and they will revive and we'll take care of it.
They're of different faces.
Who belong to the same faiths, there is no problem.
Yes.
But those who belong to different faiths, for them it is a loss.
No, my lords, every faith, Islam, my lord, Muslim.
No.
If the spouses belong to
Interfaith.
different faiths,
Interfaith.
interfaith marriage.
There is no other legal mode.
So therefore, my lord, these are regulatory, my lords. To enable something which is not happening, my lord, some people are happening, my lord, this legislature feels, my lord, that this needs to be some. That's a different thing. But it's not limited to those who are interfaith. Even others can, my lord, choose and go get married under that act. But they have a choice under whichever, and they don't depend on any form of marriage. Even the form of marriage is not prescribed by Special Marriage Act. And I was reading one of the petition, probably, my lord, it was Nivedita's petition, my lord, and they said that they have married, well and it, so be it. Lord, people must create their procedures of marriage, forms of marriage. Let it evolve. We have come, heterosexuals have reached here through ages, my lords. Since Navtej, my lord, we are only 4.5 years. It's hardly such a period, my lord, where let the society, my lord, let there be more debate, more acceptance. Let the parliament feel confident that something can be done. All that, my lord, is not before your lordships in any affidavit, my lord.